and society. With over 300 professionals and a nationwide presence, we are market leaders in debt syndication and stressed asset advisory. Resurgent offers a 360-degree service model, supporting businesses across their entire financial life cycle, from project appraisal, valuations, and regulatory compliance to capital raising for early and growth stage companies, and further to stress resolution and insolvency advisory. We are with you at every critical stage. Tailored solutions to meet your needs. Resurgent India Knowledge Series in collaboration with Resurgent Legal LLP presents live webinar on Impact of Amendments in IBC on CIRP and Liquidation Process. Moderator Ms. Tanya Anand, Head, Real Estate Resolutions, Resurgent Resolution Professionals LLP. Eminent speakers: Advocate Prashant Tripathi, Partner, Firm PMRT Legal; Mr. Azim Tariq Khan, Insolvency Professional, Corporate Law and Litigations Consultant.
Good afternoon, everyone. On behalf of Resurgent India, I extend a very warm welcome to all our participants to today's webinar on impact of amendments in the Insolvency and Bankruptcy Code on the CIRP and liquidation process. So the Insolvency and Bankruptcy Code has been one of India's most transformative economic legislations. Since its enactment in 2016, it has continuously evolved through judicial precedences, regulatory reforms, legislative amendments. The recent Amendment Act marks another significant milestone in this journey by attempting to make the insolvency framework more efficient, transparent, and value-driven. Today's discussion aims to understand not only the legal changes introduced by the Amendment Act, but also their practical implications for insolvency professionals, creditors, resolution applicants, and legal practitioners and other stakeholders. We are privileged to have with us two professionals who have extensive experience in the insolvency ecosystem. It is my pleasure to introduce our first speaker, Mr. Azim Tariq Khan, Insolvency Professional with Resurgent Resolution Professionals LLP. Mr. Khan has handled numerous CIRP cases across diverse sectors and brings with him valuable practical experience in navigating complex insolvency proceedings. Joining him is Advocate Prashant Tripathi, founder of PMRT Legal. Mr. Tripathi is an experienced insolvency practitioner and regularly advises and appears before various judicial forums in matters relating to the Insolvency and Bankruptcy Code. His practical and litigation-oriented perspective will undoubtedly enrich today's discussion. Gentlemen, thank you so much for joining us today. So without taking much of your time, let us begin with our discussion today. So my question is to Mr. Azim Tariq Khan. Sir, the Amendment Act has introduced significant changes to the initiation of the CIRP. Could you explain how the process of initiation of CIRP has changed post the Amendment Act and what practical impact these changes are likely to have on creditors as well as the corporate debtors?
There are the significant change in the wordings in the section 7, 9 and 10. For operational creditor, they may initiate corporate insolvency of any corporate debtor under section 9 and any financial creditor under section 9 and corporate applicant under section 10. But there was a number of landmark judgment of Supreme Court multiple times refined the interpretation and evolved jurisprudence give that there was some glitch. For example, if you go to the section 7, which talk about the initiation of CIRP by the financial creditor, so it used the word may by order. It means the adjudicating authority as and when ascertained there is a debt and default, the word uses the may. When you go to the section 9, which is talk about the initiation of CIRP by operational creditors, so they say about the adjudicating authority shall by order. So in the Vidarbha case, it was decided that it was discussed that the NCLT or adjudicating authority have a discretionary right in the matter of the financial creditor matters to decide whether to admit or not. And however, the Section 9 application, there is word used shall. It means that it is mandatory to admit or reject. But in Vidarbha case and later on judgments, Supreme Court clarifies that the first judgment, landmark judgment of innovative shall prevail. It means that it is not a discretionary right. If there is a debt and default, then the adjudicating authority must admit the application. Now come to the Section 7. Section 7 remove the word may and substitute by the word shall, and also made an specific provision that if the adjudicating authority found that there is a debt, there is a default, and there is default is recorded in the information utility, then adjudicating authority shall not see or hear any argument. They must admit the application. This is come by virtue of Section 215. When we go to the Section 215, which talks about the submission of the financial information to the information utility. So now there is also change in Section 215, which made the mandatory for operational creditor to file financial information and record of default in the information utility, presently which is the NESL. So now they change in the Section 9 also. They have not changed exactly in the Section 9. They amend Section 215. By virtue of change in 215, operational creditors are also mandatory to file default at the NESL. Now come to the Section 10. Section 10 is the initiation of insolvency resolution process by corporate applicant itself. So earlier there are three sets. First is Section 7, which is by the financial creditor. So financial creditor given a right to propose an interim resolution professional. Now come to the Section 9, they give may propose. It means it's not mandatory for the operational creditor to propose a name of IRP. And now come to Section 10. Earlier Section 10 says the proposal of IRP, but now amendment clearly removed the said provision. So now this is the discretion of the adjudicating authority to appoint IRP. So these are the major changes. And why these changes are come? Because there are the number of issues evolved and notified by the Honorable NCLT and NCLAT, then most of the operational creditor with the collusion of the corporate debtor dragged a viable company into the liquidation, into the CIRP regime to just avoid the legitimate dues of the financial creditor. So now the Amendment Act also add another provisions under offense and penalties that if there is any essence of the collusion found by the adjudicating authority where operational creditor deliberately involved, then they make a heavier penalty. So these are the major changes which may make a hurdle for the frivolous CIRP initiation, because the purpose of the IBC is to the value maximization and also the resolution. It's not the platform to just avoid the recovery, avoid the resolution, or avoid the legitimate dues depletion by a corporate debtor. So this is my submission as per my understanding and prevailing laws. So
Right, sir.
Prashantji can also add on it, because Prashantji also a seasoned professional in the matter of SARFAESI and DRT. So they are also, they make a light on it that as and when any SARFAESI action is taken or any DRT action is taken, so corporate debtor arrange a fake operational creditor and bring the CIRP application before the Honorable NCLT and enjoy the moratorium. So all the proceedings of the recovery stand suspended. So these are my submission, Tanya.
Yes, in fact, I agree with Tariq ji on this. In most of, or I would say, in majority of our cases that we faced, what we observed is that in most of those cases, in fact, the CIRP proceedings were usually taken recourse to by the operational creditors or at the behest of borrowers or any other person in collusion with borrowers only after we have initiated proceedings under SARFAESI Act. Same was for the personal guarantors also. In fact, Unfortunately, my experience has been worse with Punjab and Haryana, where in majority of our cases, the moment we had initiated SARFAESI proceedings, immediately a Section 94 proceedings application used to be filed, and then with the interim moratorium coming into picture, our entire actions, the banks and BFC's entire actions were put on hold. So these were somehow these proceedings were used to be abused by certain borrowers, not all, but yes, certain borrowers used to abuse. And I think because of these things, this was one of the primary reasons for removal of interim moratorium. In addition to it, the procedure for restricting the withdrawal of CIRP that I will deal separately. I think that has also been done only to minimize the abuse of IBC proceedings.
Thank you so much, sir. So that sets our context very well. And with that background in place, let's now look at some of the more important amendments individually. So, Azim sir, again to you. Once the CRP commences, the role of the stakeholders becomes equally important, particularly that of the Committee of Creditors. That brings me to my next question. One of the most notable changes under the Amendment Act is the enhanced role of Committee of Creditors during liquidation. So, could you explain how the powers of COC have expanded during the liquidation process as well, and what purpose does these changes seek to achieve?
Yeah, actually, there were two concepts. When the CIP is going on, there is the concept of the COC, and as and when the liquidation is admitted, it converted to the Stakeholder Consultation Committee. Actually, the Code 2016, which is the original enactment, which never talks about any Stakeholder Consultation Committee. But the IBBI, with the motive to enhance the transparency and control over the liquidation process, make a 31A regulation in which they brought a concept of the stakeholder consultation committee. And in the stakeholder consultation committee, there was also the director, there was also a operational creditor, also financial creditor. So now the recent amendment says that when the section 21 is relating to the COC, which says that the financial creditor which are not related to the corporate debtor shall be the committee of creditor, and all others shall be the participant. If there is the operational creditor, if there is any directors, then they shall be the participant of the meeting without having any representation and any voting right. So the same things enlarged to the liquidation. Now the COC, which is constituted and operating and controlling the entire CIRP during the corporate insolvency resolution process, shall be the same controlling authority during the liquidation. There shall not be any change, because by virtue of omission of section 38, 39 and 40, which was relating to the admission of claim, verification of claim and determination of claim during the liquidation process, is already omitted. But there is an explanation. The cases which are the ongoing, in that cases, such verification and consultation is permissible. But the cases which are new cases in which the application of liquidation is pending, they must follow these provisions. But when we go to the section 2111, it also talks about the ongoing project or ongoing liquidation process. So if at present, as on the date of 26th May 2026, on which date the said section is notified, if there is any liquidation proceeding is going on, then the COC shall take the controlling stake. So these are the major changes. They have enlarged to the liquidation process also.
Okay. Thank you so much, sir.
In fact, for the said reason regarding this claim, section 42, which provided for appeal against the decision of liquidator for rejecting or approving the claim, that has also been omitted now, because same claims will now follow to the liquidation proceedings also. Though those creditors who could not file those claims, there is a provision permitting them to file their claims.
Yes, sir. And this is also the concern about, because when we go to the judgment, so they says about that the resolution professional or interim resolution professional has no the adjudicating authority. But when we go to the old 2020 then it gives the adjudicatory power to the liquidator, who will decide whether to admit or not. So
Yes.
these are all the ambiguities that come across to the Honorable Supreme Court and NCLT and NCLAT. So such kind of amendments and modifications made in the parent statute.
Okay. Thank you so much, sir. So my next question is to Mr. Tripathi. Sir, the Amendment Act has introduced important changes, specifically concerning settlement and withdrawal of insolvency proceedings. So can you please explain how these provisions have evolved and what impact are they likely to create on the insolvency framework specific to withdrawal of
Yes.
CIRP process?
Please. Thank you for the question. So, if we trace back to the time before this 2026 amendment, the section 12A that was there, it did not contain any time limit or the stage at which the withdrawal of the CIRP proceedings could be permitted. And because of this absence or because of this lacuna, what we used to observe during court proceedings was at the fag end of these CIRP proceedings, the borrowers used to start negotiating with the creditors, and in most of the cases, in fact, where the resolution applicant started their due diligence, expended a lot of amount in conducting that due diligence. At that very fact end, the borrowers or the cooperators used to negotiate with the creditors, and then proceedings for withdrawal of those CIRP proceedings used to take place. This actually demotivated a lot of resolution applicants. At the same time, this was also a negative factor when we look into the aspect of CIRP, because all the stakeholders that were involved had put in a lot of efforts, and permitting settlement at the last moment was demotivating for all those stakeholders involved. So considering this problem, Section 12A has now been substituted, and while the 90% approval of COC that was required earlier has been retained, with the new 12A coming into picture, withdrawal is prohibited before constitution of Committee of Creditors and after the first invitation for submission of resolution plan has been issued. That is after Form G has been published. So this fixation of time period between which the COC cannot, even COC cannot approve the withdrawal assumes a lot of significance. Additionally, 12A now requires the withdrawal, in fact NCLT to allow the withdrawal within 30 days of the filing of the application. As far as impact is concerned, my understanding says for financial creditor, I can say it has in fact for financial creditors as well as for corporate debtors, I would say it has a mixed consequences, for the reason that flexibility that was earlier available for the creditors and debtors to enter into a settlement even at the fag end has now gone. Now, even if, because see, there were certain genuine cases also where the corporate debtors used to get funds at the last moment, and after receipt of those funds from whatever sources it used to get, then negotiation proceedings used to start. Now, with this 12A coming into picture, if such a genuine corporate debtor receives fund at the end, at the fag end, after the Form G has been published, now even though it has received funds, even though creditors are interested in settling the matter, even if creditors are receiving 100% of their dues, my understanding says with this new 12A coming into picture, they will not be permitted to proceed for withdrawal of CIRP, and therefore the creditors as well as the corporate debtors will be impacted in such a manner. So, please, sir.
Prashantji, one thing I would like to add. As the insolvency proceedings are in RAM process, so there is as and when the insolvency is admitted, then the all proceedings become in RAM. The motive behind it, the introduction of this new 12A in the new avatar is because earlier it uses the word the applicant. So the applicant who initiated the CIRP proceeding shall make an application. So there may be a possibility that okay, all 90% stake COC members who are the financial creditor are willing to amicable resolve the issue and withdraw the CP number company petition, but the applicant is not ready. So now they have changed the word the resolution professional. It means it is not limited to the applicant. Now, if there is any proposal, as Tripathi said, okay, after constitution and before the first Form G issuance, during this tenure, if any promoter or any settlement happen, then resolution professional may make an application on behalf of the COC. So these are the ambiguity because there are the number of cases the application was filed by the operational creditors, all bankers are ready to settle, but the operational creditor is not willing to settle. So these are the situations.
Correct. Thank you, sir. So although legislative changes are important, one of the biggest practical challenges faced by the RP is not often legal, but is also operational, particularly when promoters or the suspended management fail to cooperate. So that is an issue that almost every insolvency professional encounters in practice. So my question to you, Mr. Azim Tariq Khan, is that how does the Amendment Act strengthen the framework for dealing with non-cooperation of the directors? And do you believe these provisions will make CIRP more effective?
Yes, actually, there was two definitions. When we go to the section 3 and section 5, there is the definition of officer and definition of personal. So when the earlier section 19, which talk about the filing of an application by the resolution professional as and when he faced the non-cooperation from the personal and its promoter and its director. Now the section 19 changed, substituted with a new word, any person who is or has. It means any promoter, director or any personal who is falling under the definition of the KMP, directors, promoters and employee, whether he is in the present time as on the date of the CIRP or any anterior time, both are liable to extend the cooperation to the resolution professional. Now come to the CIRP regulation. Earlier, regulation 3A was inserted by the IBBI to enable the resolution professional and interim resolution professional to take a robust action against the non-cooperation by the promoters and personnel. So they have introduced that like the requisition of the notice, but there was a limitation, only directors and promoters. So now the horizon now extended to the any person who is associated, and also the one specific line added in the substituted proviso that any contractual party, suppose if there is any operational creditor, if there is any service agreement, any counterparty of any agreement, then they also covered under the definition of the personal, any person. So it expanded the horizon. Now the IRP RP can go to the any person who is associated to the corporate debtor for collection of information and collection of financial information to make a proper information memorandum. The motive behind it is that the drafting a proper information memorandum. Until and unless the proper information not available to the resolution applicant, they are not able to give a proper resolution plan. They are unable to give the treatment. In the most of the cases, it happens that after issuance of the information memorandum, submission of the resolution plan, new asset identified, any RA resolution applicant. So that caused a huge and prolonged litigation. So for avoiding these all things, such changes and modifications made in section 19.
Correct, sir. Thank you so much, Azim, sir. So my next question is to Mr. Tripathi. Sir, one of the most recurring criticisms of the IBC framework till date has been that viable businesses sometimes proceed towards liquidation despite genuine prospects of resolution. And the recent amendments appear to address this concern. Basically, which to the restoration of CIRP during pendency of a liquidation application. So could you please explain how this provision promotes resolution over liquidation and why it is considered as a significant reform?
See, in fact, two things have been done, two amendments have been done in this regard to ensure more sustainability for the corporate debtor. First is they have permitted restoration. Second, they have also permitted reinstatement of CIRP. So different circumstances have been provided for the same. Section 33, subclause 1. In fact, if we go back to time before amendment, what we used to say, once no resolution plan has been received, or if resolution plan though was received by COC could not be approved by it, or if approved by COC, NCLT rejected it, or if there was a contravention, in all these four eventualities, liquidation was the ultimate consequence. And liquidation means, in simpler language, that we used to call death of the company. So now this 2026 amendment has stressed more upon resolution than proceeding towards liquidation. So section 33 1, which provided for liquidation in certain circumstances, now subsection 2 has been subsection 1A has been added in it after subsection 1, and this subsection 1A provides for restoration of the CIRP in two circumstances. First is the circumstance where the NCLT has rejected the fact does not receive any resolution plan and the period of CIRP had expired, and where the NCLT had rejected the resolution plan that was received under section 31 for non-compliance of various requirements that were prescribed therein. So in both these circumstances, restoration has now been permitted. In case the liquidation order was passed under circumstances that are prescribed under clause 1, that is where no resolution plan was received, then NCLT can, subject to the COC's application with 66% vote, can permit restoration of the CIRP for a further period of 120 days. In circumstances where the condition mentioned under ground B, clause B is there, that is, a resolution plan though was approved but was rejected by the NCLT due to it contravening certain requirements of section 31. In such cases, NCLT will restore the CIRP from the stage of resolution plan, and further period of 120 days have been given for completion of this process. However, in case under eventuality A and B, the resolution process is not completed within 120 days, then ultimate consequence again is liquidation, because this 120 days is only for once. No further extension has been permitted. Then previously we used to have a situation where resolution plan duly approved by NCLT, in certain circumstances its implementation was not properly adhered to by the corporate debtor. The resolution plan in certain circumstances was contravened by the corporate debtors, and in all those cases liquidation was permitted. Now with 2026 amendment, discretion has been given to NCLT to reinstate the CIRP, though circumstances will be subjective, because it says NCLT, if it deems fit, can permit reinstatement. So this 2026 amendment again reinforces that the focus is more on the resolution aspect than the liquidation or the death of the company. Tariq sir, if you want to add something.
Sir, you explained very well, and it is really a good move for resolution rather than a corporate death. So one more thing I would like to add: if we see when the liquidation order passed, there was a glitch between the moratorium during the CIRP and moratorium during the liquidation.
Yes.
So when we go to the section 14 of CIRP, it talks about the prohibition of any initiation and continuation of any proceedings or any suit. But
Yes.
earlier, it was not mentioned in the section
Liquidation
33
part. Yes.
liquidation part. It talks about the continuation. It means
Yes.
initiation. It means that you cannot initiate any proceeding, but any proceeding that is pending that may continue. And there are a number of judgments related to the income tax for the assessment and the penalty and adjustment of refunds. That was come. So now the IBC also inserted a new clause under section 1, subject to the provision of 52, which talks about the relinquishment of the security interest. Declare, it means the adjudicating authority in section 14 declare the moratorium with the admission order. So now in the liquidation order, declare a moratorium for the purpose referred to section referred to in clause A and C of subsection 1, read with subsection 3 of 14, and mutatis mutandis applied to the proceeding under this chapter. It means the
Yes.
moratorium provisions of the section 14 shall equally apply to the liquidation also.
Exactly.
So
So
these are
only clause
major
A and C.
Yes, because it explicitly removed the B, because the B talks about the transfer, because during the liquidation, the liquidator had power to auction and transfer and sell the assets. So that's why the clause B is not taken in the section 33. But A talk about the initiation and continuation of the suit, and C is talk about the enforcement action. But it is subject
Yes.
to 52.
50.
If there is a relinquishment, then they will become a part of the liquidation estate, and other creditor who is willing to out of the liquidation process, then they may proceed under the enforcement action. So these are the major changes in the section 33. So Tanya, you may proceed.
So, continuing this discussion, there are notable litigative changes which relates to the removal of provisions concerning the interim moratorium. So, Tripathi sir, can you please briefly explain the rationale that's there behind this legislative change and its practical implementation on the stakeholders?
So precisely section 96, which falls in part 3, is actually for the individuals. Though with 2019 amendment, this part was notified for the personal guarantors to the corporate debtors. Now 2026 amendment has inserted subsection 4 to section 96 and now has removed the application of interim moratorium for the personal guarantors. Before amendment, the position was the moment a section 94 application or a section 95 application, meaning thereby section 94 application is filed by the debtor, section 95 filed by the creditor. So in case any of these application was filed, interim moratorium that is prescribed in the section 96 used to come, and it used to bar all the proceedings for the personal guarantors, and the litigation results showed that in majority of cases the interim moratorium was abused by the borrowers. And because the wording of section 96, which talks about interim moratorium, it does not say that the interim moratorium will come into picture on the registration of the application filed under section 94 or 95. It only says the moment it is filed. So taking benefit of this, many borrowers used to file a defective application, and our practical experiences have shown us that the moment we had filed a section, we have initiated the SARFACI actions, or when we are about to take physical possession, or when we were when the creditor used to proceed for sale proceedings. During that time, a section 94 application was only just filed, maybe a 2-page, 3-page, and with that acknowledgement number, the borrowers used to appear before the DRTs and they used to make the submission that now they have filed the section 94 application. The impact of section 94 application is that 96 comes into picture, and now no proceedings against me can proceed. So most of the borrowers started abusing this process and taking the benefit. Though in a few judgments, I think one by Kerala High Court and also by NCLAT, this was discussed that mere filing is not sufficient. it has to be a proper filing and application needs to be registered, but the position was not clarified very well because of the substantive words and substantive provision contained. So now 96 subclause 4, subsection 4 has come into picture, and the benefit of interim moratorium is no more available to the personal guarantors. 94 or 95 is filed. Based on the report of the resolution professional, the proceedings will be admitted or rejected. Once admitted, now the moratorium that is prescribed under section 101 will come into picture. Before that, there is no protection available to the personal guarantor. Another coincide of this amendment, or I would say the negative impact of this amendment, is that uh, those proceedings, those enforcement proceedings and depletion of assets of the personal guarantors will continue till the admission of the application filed under section 94 or 95. So in a way, the object with which these provisions were initially notified was to preserve the assets and basically the assets of the personal guarantors. To some extent, in my understanding, will now be adversely impacted because of the interim moratorium having gone. So that's my understanding. Tariq sir can add to it.
Tripathi ji, actually, in this scenario, you very well said and explained about the tactics used by the mostly the personal guarantor. Because as and when the SARFAESI action take place, 13.2 notice issued or 13.4 action is now initiated, so they merely file an application under section 94. And because the section says that there is no requirement of any acknowledgement or any order or any notification. So as and when it is filed before the NCLT, the section 96 interim moratorium kicks in. The major issues relating to the section 96 and 101 is when we read the section 96. So it's not it prohibit the any recovery action, but it not talks about the transfer or alienation of the asset. So during the interim moratorium, most of the personal guarantor do one thing. They enjoy the interim moratorium that any creditor cannot take any action. But during this time, they transfer their assets, either to transfer to the trust, either transfer to the any third party, or create a third party interest over the asset. Because when 101 comes, then it is specifically saying that there is a specific provision of the transfer of any asset.
Exactly.
And must one major thing here to understand, because as and when, because I'm facing certain questions from our colleagues and also to the clients when this is applicable. So there is the provision, there is the interpretation game, whether it is retrospective or prospective. Actually, it is hampering the substantive right of the personal guarantor. So it is notified by the 26th May 2026. It will operate prospectively. It means any application which is filed before the 26th shall enjoy the interim moratorium. But after filing of filing beyond 26, they will not have any enjoyment of interim moratorium. So, and one more thing, Tanya, for clarity, because when we go to the Amendment Act, there are number of things we assume that it is prospective. But most of the amendments are come with the explanation. These are only clarifying the original provision. They are not adding any new thing. So there is no curtailment of substantive right or any violation of right of any person. So these are the retrospective.
Yes. Any amendment that clarifies the existing position will always be given a retrospective effect unless expressly provided otherwise.
So these are only my submission. I think Tanya, you may go ahead.
Right. Thank you, sir. So Azim, sir, my next question to you is that another category of creditors has been significantly impacted, which is the secured creditors. So can you please help us understand how do the recent amendments affect the rights and options available to the secured creditors during the insolvency and liquidation proceedings?
Actually, these all these explanation added in the definition of the secured creditor. So the motive behind and object behind is to clarify. Actually, earlier when it was not clarified, like the Rainbow judgment come, Prabjit Singh Soni judgment come, they talk about that any institute creating a first charge by operation of law shall be considered as a security interest and they fall under the secured creditor. But when we go to the section 53, which is the waterfall mechanism, that does not talk about the secured financial creditor. It talks about the secured creditor.
Yes.
So there was a mismatch. So now that was clarified that now any security interest shall be considered only when there are the two or more parties, and there should be a contractual arrangement. It means there must be an agreement or arrangement between the party of creation of security interest, and it is specifically mentioned in the explanation that any charge created by the operational law shall not be considered as a security interest. Now the prospectivity and retrospectivity to be judged here. It is only an explanation. So if any case, any CIRP or liquidation is going on, so you have to consider those operational creditor which was the secured creditor by virtue of Rainbow or Prabjit Singh now become an unsecured operational creditor, and treatment shall be made in accordance with the section 53. Now come to the section 53. They have also changed, add an explanation, because earlier the section 100 of transfer of properties that talk about the charges and the priority of charges. So it is the well settled during the SURFACE and during the DRT matters. Then the whosoever the first charge shall have the right to collect their dues first, then second and third and pari passu, etc. But the section 53 not talk about any priority. So now they add an explanation that a secured creditor shall be the secured to the extent of the security interest, and remaining portion shall be unsecured. So it means, for example, if any creditor have a claim of rupees 100, and after valuation it is arrived that his the security interest is only limited to rupees 50, then he is considered as a secured creditor for rupees 50, and balance 50 rupees claim shall fall under the unsecured creditor. So these are the changes. They are the major changes. Now the all government, there may be possibility that the government department may challenge this explanation for the constitutional validity, but there is very little chance. So this is Prashantji, if you want to add and clarify it, so then.
No, nothing as such required. The only thing is that they have, as you mentioned, they have added this explanation expressly to to the definition of security interest, thereby removing the impact that Rainbow had caused. So by operation of law, no security interest can be created, and therefore you will not be treated as a secured creditor. Again, with this definition that now for you will be considered as a secured creditor based on the value of security interest, that I think will be prejudicial to a lot of financial creditors, because to the extent they are secured, they will be placed at a higher pedestal in the waterfall mechanism, and for the same debt, because the value of security interest has gone down, for the remaining they will be considered as an unsecured creditor, which doesn't make a lot of sense to me, and I think it will be causing a lot of prejudice to various financial creditors.
Actually, sir, in my understanding, actually there was a Sidco Leather case of Supreme Court, which is mostly debated in all the IBC matter where the liquidation is happening. Because the Sidco Letter is also the Supreme Court, so that is the binding precedent, but it is relating to the SURFACE action, which talks about the priority of charges. But when we come to the section 53, which talks about only the secured creditors, so it means the all secured creditor having any value, whether it is the first charge, second charge, parupasi charge, and number of charge, they become at par. So they all receive the funds on pro rata basis as per their claim. So, but there is also the number of judgment which talks about the security interest, but it is also the discretion when we talk about the resolution process. So that change, that section, that is I think 31.4 or 34, that talks about the right of the committee of creditor, whether they consider the security interest or not. But when we come to the liquidation, it is now clarified by explanation that the eligibility shall be based on the security interest, value of security interest. So now let's see, sir, if there is any precedent, it clarifies.
Another thing that, sir, I feel is that with this explanation coming into picture, I think more creditors will now, even otherwise, the secured creditors were initially interested more in liquidation and getting their property or rather security interest enforced during liquidation. Now with this explanation, I think that ratio will grow more. more number of secured creditors will try to go out of liquidation process and realize their security interest beyond the liquidation state.
So this is, I think there is a reason, because when we talk about the section 52, so most of the secured creditor having the good security value prefer to not relinquish their security interest, and they go under the SURFACE or other realization of asset under the liquidation regulation and get the good amount rather than the other stakeholder who have relinquished. So I think these provisions are added to just balance the between the relinquished and unrelinquished security interest. And you are also right, sir. Let's see if there is any precedent set.
Okay, Adilkar, let's.
In fact, sir,
Yes, sir, please.
yeah. So what I was saying, the subsection 2, the illustrations that have been added to subsection 2 of section 53, they also bear certain significance, where they say the contractual
Yes, sir.
arrangements between recipients under subsection 1 with equal ranking, if disrupting the order of priority, those shall be disregarded. And they have given two illustrations. One is the first illustration deals with the workman and secured creditor, and they say if they have certain arrangements saying that in the event of liquidation or insolvency, the secured creditor debt shall be cleared before other debts of workmen. This contractual arrangement has to be disregarded. The second illustration that they give is if there are two secured creditors and then those secured creditors have entered into a contractual arrangement saying that in the event of insolvency or liquidation, the dues of first secured creditor will be paid in priority. Then such contractual arrangement has to be shall not be disregarded. Basically, that contractual arrangement has to be considered. However,
I think it is always in the consortium arrangement wherein they have the inter se agreement.
yes.
So Tanya, if you have
Right.
more.
Yes, so that was an extremely practical insight. However, I'd like to move towards section 28A, which relates to the consolidation of the asset pool. So, Azim sir, can you please explain what this provision seeks to achieve and how it contributes towards value maximization under the code?
Actually, it's also linked to the section 96 also. Actually, in normal parlance, when a bank lend a money to a borrower, it means a corporate debtor. There are also the promoters or a group companies who extend the personal guarantee or the corporate guarantee. So when the corporate debtor come under the CIRP, as per the contract at section 128, by virtue of there is the liability of the guarantors and the principal borrower is the coextensive, they prefer to invoke either SURFACE or any other enforcement action to take possession of the asset of the personal guarantor and corporate guarantor. So now this 28A is a bold move to consolidate the asset, make an asset pool of the corporate guarantor, personal guarantor with the corporate debtor for the amicable resolution. So now the suppose for example A is a corporate debtor who is the insolvency resolution process already going on, and B is the corporate guarantor and C is the personal guarantor, and their proceedings already or either going on or the creditor taking the possession of those assets. So now the resolution professional of the corporate debtor may approach with them with the approval of the Committee of Creditor having the 66% votes to transfer the asset into the asset pool for a combined resolution, because there is creditor is same. So creditor cannot recover their dues twice more than the actual debt. So suppose they have to collect only 100 rupees. So now the all assets shall be clubbed, and they can the resolution applicant may propose a consolidated plan for these assets also. And as and when the recovery comes under the resolution, either in the liquidation, then the same shall be distributed as per the debt claim. So these are the newly inserted 28A.
Sir, so this amendment has also introduced new explanations under section 31, which is basically reinforcing what is commonly referred to as the clean slate theory. Can you please shed some light? Can you please explain the significance of these explanations and how they provide greater certainty to the successful resolution applicants?
As we also discussed that as and when the explanation is added, it is the clarificatory. It's just clarifying the provision. It is the retrospective. It means the all cases which are the pending today. Okay. Why these explanation is added? The objective behind is the two landmark judgment. One is the SR case, which talk about that there is the clean slate theory. It means that any resolution applicant is coming, they must have a clean slate. But additional burden should not be put on the new management to clear off the debt or clear any claims. So, and thereafter the Ghanshyam Mishra case come. If any claim is not part of the resolution process shall be extinguished. So now they clarify by adding the explanation that any claim which is not the part of the resolution process shall be extinguished. But one is glitch here. It also talks about the guarantors, because under the Contract Act, if the guarantor discharge the liability of principal borrower to the creditor, then for such person he will become the creditor to the extent of the amount or liability discharge. So now it is clarified in explanation. If guarantor had not made a claim during the insolvency resolution process, then there shall be no subrogation right. It also comes from the Supreme Court judgment, which talks about in Lalit Kumar Jain, which says about that if any personal guarantor discharge, if resolution plan is approved, then you cannot enjoy the subrogation right. So for this purpose, it is introduced. Now the guarantor has to make sure that if they discharge any liability, they must submit their claim during the CIRP. Then only they will get a claim resolution. Otherwise, it will be extinguished. So these are the explanation. It is not prospective; it is retrospective. If there is any resolution process is pending, that equally applicable. Shanti, you may add in this.
No, so that's perfectly right. In fact, in practical fields, certain queries were received on this in this context for the co-borrowers. In certain cases where individuals are only mentioned in the loan agreements as co-borrowers, they do not sign any separate personal guarantee or any other document which may bind them as a personal guarantor. So certain queries were raised in this regard as to what would be the liability of those co-borrowers. So I think this explanation will also clear that position because co-borrowers are not separate. There is no separate status of co-borrowers under law. It is just a term that has been devised in practice for mentioning all other persons other than the main borrowers as co-borrowers. So I think that this explanation number 2 will help us in that position also.
Okay, so my final question is to you, Mr. Tripathi. I'd like to discuss Section 33, which governs one of the most critical stages under the code, the transition from resolution to liquidation. So, Section 33 has undergone significant changes. Could you briefly walk us through these amendments and explain how they impact the transition from resolution to liquidation?
See, in fact, we discussed this thing when we discussed the restoration and reinstatement. Now, as I mentioned earlier, that before passing a liquidation order, earlier the position was the moment there is no resolution plan or resolution plan received by COC is rejected, or resolution plan if approved by COC rejected by NCLT, the ultimate consequence was liquidation. Now 2026 Act gives a breather. Now before passing of an liquidation order, even those circumstances have taken place, even those eventualities which I discussed that were there for passing of a liquidation order exist. But with 2026 Amendment Act, before passing a liquidation order, COC with 66% voting rights can file an application and request the NCLT to allow restoration. And as I mentioned earlier, if the liquidation, if there was no resolution plan received during CIRP, NCLT can restore it and permit 120 days for further resolution. If the NCLT had rejected the resolution plan, then it can restore the CIRP from the stage of resolution plan for 120 days, and again attempts for resolution can take place. Another, where resolution plan was contravened, a resolution plan that was approved by NCLT subsequently contravened by the corporate debtor. Now, earlier it was only the liquidation. Now, before passing liquidation order, it can direct for reinstatement of CIRP again. Another thing, as Tariq sir also mentioned, that now stakeholders consultation committee that used to come into picture after liquidation proceedings used to commence has now been removed. So same COC will come into picture. The only thing is that those creditors who are related party will not form part of it. And the other basically, in essence, what I should say is section 33, the essence that was that the liquidation has to be taken recourse to. Now more emphasis has been laid upon the resolution. All attempts through which a corporate debtor can be resolved have been, in fact, I would say, done in this section, and liquidation has been put at the last recourse available against a corporate debtor.
Thank you so much, sir.
To add anything?
Yes.
So, is there any questions from audience, Tanya?
I'd like the audience to kindly, I request the audience to kindly put up any questions if they have. They can write their questions in the chat section. So, sir, we have one specific question, if we could wrap up quickly. So, the question is that the Amendment Act now permits multiple resolution plans, including plans for sale of individual assets rather than only a going concern sale. So do you think this will improve value maximization, particularly in complex real estate and manufacturing insolvencies?
Actually, Tanya, there is change in the definition of the resolution plan. Because earlier it includes only the rearrangement, reorganization, merger, amalgamation, and demerger. Now it includes the sale of asset. So, if the resolution professional with the consent of the COC decided to sell the one or two assets, then they may sell to the different person, different resolution applicant, but the procedure should be followed. For example, there is a manufacturing unit having the 2 or 3 units or 2 or 3 land parcel, and COC decided that now there is no possibility to sell the entire corporate debtor as a going concern. Then they may sell it on a piecemeal basis during the CIRP. So now the resolution professional to issue the expression of interest under section under regulation 36A for the particular asset. In that case, there may be a number of Form Gs for the different assets, and there may be a number of resolution plan. The purpose is the value maximization and resolution of the corporate debtor by way either it go to going concern basis or either in piecemeal basis. So these are the changes, and they more encourage the involvement of the all stage resolution applicant. For example, it's not limited to, it would not be limited to the high net worth resolution applicant. It means the small players may come into the picture and they participate in the resolution process. If there is a more competition, then the more value maximization.
Okay.
I think it is a good move because it will in fact more investors will come for, as Tariq sir mentioned, for a small pool of assets. They can definitely come and get those assets. There will be definitely a value maximization.
Because there are many cases I have seen, like the manufacturing unit have a 200 acre of barren land. This land is not required for the purpose of manufacturing activity. These were just an investment of the corporate debtor. So any real estate player or any infra player who has who's shown the viability, then they may come and place a resolution for the particular asset, which is not directly impacting the manufacturing facility. So there must be a balance between the sale and entire resolution. The resolution professional and COC has to look if the object of the IBC shall not be hampered.
Right. Thank you so much, sir. So with that, we come to an end of today's webinar, and I would sincerely like to express my gratitude to both our speakers for sharing their valuable knowledge and practical experience with us all. I also thank all the participants for joining us today. We hope this discussion has provided meaningful insights to the recent amendments and their practical implementations on the insolvency ecosystem. On behalf of Resurgent India, I thank you all once again for your participation. Have a wonderful day ahead, and we look forward to welcoming you to our future knowledge sessions. Thank you so much. Thank you all.
Thank you, Tanya. Thank you, Tripathi ji.